Good afternoon, everybody. We're just going to wait a few minutes for all our delegates to join the webinar before we start. Good afternoon, everyone who's just joined us. We'll be starting very shortly. We're just waiting for a few more people to join. Welcome and thank you for joining our marriage law webinar. I'm Wendy Campbell-White. I'm part of the business and content development team at LexisNexis. I'd like to share a few housekeeping rules and the program before we get started. All delegates will be muted during the webinar. The presentation by Professor Bridget Clark should take about 45 minutes. Then we'll move into a 10-minute Q&A session, which my co-host will facilitate with Professor Clark. Please send through your questions using the Q&A tab at the bottom of the screen, and we'll try to get through as many as possible. You can use the chat box for general comments or for questions that aren't for Professor Clark to respond to. A post-webinar emailer will be sent out to all delegates with a link to the webinar recording. Before I hand over to my co-host, she merits an introduction. The Law of South Africa, or Lawster as we refer to it, has been a flagship publication for over 40 years. The editor-in-chief behind this encyclopedia for nearly 3 decades is your host, Mandy Kuna. Prior to this, she lectured constitutional and administrative law with Professor Devonish at Howard College, UKZN. Mandy has a BA LLB cum laude from UKZN and a master's in law from the University of Cambridge on full scholarship. She is responsible for determining which Lawster titles are published and when, and she selects and commissions the many eminent authors who contribute. She has established an exceptional review panel for Lawster content that includes 2 retired Deputy Chief Justices, Judge Hurrams and Judge Moseneka, as well as Judge Wallace and Professors Farris and Nkube. I'm now going to hand over to Mandy to introduce our topic and presenter today.
Thanks, Wendy. Good morning, everyone. Thank you for joining us for our webinar today. In this webinar, our expert, Professor Bridget Clark, presents a fascinating overview of marriage in South Africa and how the law is changing so as to bring about conformity with the Constitution. She focuses on the existing matrimonial law and its difficulties, as well as the new marriage bill, So a bit more about Professor Bridget Clark. After completing her master's degree at Cambridge University, Professor Clark, Bridget, qualified as an attorney and conveyancer of the High Court of South Africa. She then began her career in academia, firstly as senior lecturer at UCT, and then Rhodes University, where she completed her doctorate on child maintenance in South Africa. In 2002, she commenced her lecturing career in the United Kingdom, first at the University of East Anglia for 10 years, and then at Oxford Brookes in Oxford as a senior lecturer. Since 1995, Bridget has been the general and contributing editor of LexisNexis Family Law Service. She is the author of over 50 journal articles and chapters in books, and the Handbook on Child Maintenance in South Africa. She is also the contributor of the title Marriage in the Lawson series. In April 2019, Bridget took up a senior lectureship at the University of KwaZulu-Natal, lecturing the law of persons and jurisprudence, and teaching and supervising postgraduate programs on child and family law. Bridget, welcome, and over to you.
Thank you, Wendy, for that very kind and full introduction. I will be sharing my screen with you. I look forward to this presentation on marriage. And I want to ask a question first. How do you define marriage? How is marriage defined in different societies? Marriage, like the South African diverse society, means different things to different people. It could mean anything from, let me start my slide, sorry, just, if you look at an overview of marriage, there's a wide diversity of meanings, and it is a very diverse topic. Like families, a marriage has a very diverse meanings for different people, as I say. And the South African Constitution celebrates and upholds this diversity. And if you look at try to get a definition of and meaning to that, I think the one meaning that we could all agree on is that marriage is a legally and socially approved union that is regulated by laws, rules, customs, and beliefs. And if you look at this little graph here, you will see that in 2021, there were 106,499 marriages, customary law marriages, 2,676, and civil unions, 2,240. So marriage is those kinds of marriage, civil marriages under the Civil Marriages Act, which I'll talk about just now, constitute a large volume of those marriages. But global and local trends have seen marriages decreasing each year. Marriage is definitely becoming less common as unmarried couples are choosing to live together, and I will address that fact in greater depth. So information contained in the statistics here, you will see 106,000 marriages, as I said. That shows a drop of 60,000 from the number of marriages in 2012, which was 161,000. So marriage is definitely on the decrease. Now, the structure of this presentation will be firstly to look at the existing South African matrimonial law and its difficulties, as Mandy said. And then secondly, to question whether and how this existing matrimonial law is unconstitutional or inconsistent with some of the provisions of our Constitution, which provide for the rights of women and children. Child marriage is allowed under certain circumstances with consent, which is unconstitutional in terms of Section 28(2), and religious marriages and life partnerships, which are not regulated. And that is also an aspect of concern in terms of the Constitution. So I will then look also at the fact that our existing matrimonial law is fragmented. We only had the Marriage Act of 1961, which allowed for the solemnization of civil or religious marriages between a man and woman. And then we gradually got the Recognition of Customary Marriages Act and the Civil Union Act. But it is not all contained now in one statute. So the argument that it is fragmented and in different statutes. There's also the problem that it is out of date. The Marriage Act of 1961 is now 60 years out of date, and there are arguments that needs to be updated. So I will also be looking at the background to reform, the new reform proposals. The South African Law Commission has been working very hard on this and produced several bills, and is working on other papers on matrimonial law, which is just the one that has just been produced. And then there's another one on alternative dispute resolution and one on spousal maintenance. And I'll then be focusing primarily on the draft marriage bill, which was presented to Cabinet and is open for comment until the end of this month, August 2023. And I will be focusing on some criticisms that I have of the bill. So that's the structure. So as I said, it is fragmented. We have marriage in South Africa recognized under 3 separate statutes. The Marriage Act of 1961, which was the original act which covered civil marriages between opposite sex couples, and was not available and is still not available to same-sex couples. Then in 2000, and we enacted in 2000, we had the Recognition of Customary Marriages Act, which allows for polygamous marriages under certain circumstances. And then eventually in 2006, we got the Civil Union Act, which allows for the solemnization of civil or religious marriages or civil partnership between 2 people, regardless of gender. And the legal consequences of a marriage under the Civil Union Act are exactly the same as those under Marriage Act, but same-sex couples are not permitted to marry under the Marriage Act. They have to marry under the Civil Union Act, and there are arguments that creates a kind of separate but equal regime for same-sex couples, and they're not offered civil marriage in terms of the Marriage Act. There is no legislation specifically dealing with religious marriages or life partnerships. So that is a problem and a gap in our law. Another problem is that minors' marriages are currently allowed under the Marriage Act and the Recognition of Customary Marriages Act. So boys under the age of 18 and girls under the age of 15 must get the written consent of their parents to marry like other minors, plus they need to get the consent of the Minister of Home Affairs. But any boy under the age of 18 and any girl under the age of 18 will need the written consent, obviously, of their parents. But if they are under those ages, they, in addition, need the consent of the Minister of Home Affairs. And the same applies to the Recognition of Customary Marriages Act. But in terms of the Civil Union Act, there is no provision for child marriage. Most boys and girls must be over 18. So arguments are that the current marriage law is unconstitutional. It does allow for child marriage, which is contrary to international law, contrary to the recent Southern African Development Protocol, which has been signed, contrary to the African rights, Charter on the Rights and Welfare of the Child, and it's contrary to Section 28 too. It's obviously not good for children to be married that young. It is not in the best interests of the child. That has been firmly established by research and is fairly obvious. There's discrimination against women because polygamy is allowed. A male spouse may take more than one wife, but a wife's spouse may not take more than one husband. There's a lack of provision for women in cohabitation arrangements, where they are often left destitute at the end of those relationships. That is, research has been done on that in South Africa. And there's just definitely discrimination against women in religious marriages. So I'll be looking at those briefly. With regard to Muslim marriages, there's been an unconstitutionality ruling. There were many cases, starting with the case of Ryland versus Edwards, in which the courts came to the rescue of women left destitute at the end of their marriage, when they couldn't get the provisions of the Divorce Act to help them, and they couldn't get the provisions, they obviously were not married in terms of the Marriage Act. So there were a lot of cases which culminated in the President of the Republic of South Africa, in another case, versus Women's Centre Trust, Legal Centre Trust, in 2020, in which the Supreme Court of Appeal ruled that Parliament needed to remedy those defects to ensure the recognition of Muslim marriages as valid marriages, and to regulate the consequences arising from the failure to recognize those marriages. And that was confirmed by the Constitutional Court in the Women's Legal Centre Trust versus the President in 2022, in which the Constitutional Court gave the government 24 months to provide legislation, or to provide legislation to correct that position, that lacuna in the law. In terms of life partnerships are really those who, regardless of gender, live together without a valid marriage or civil union. And none of the consequences of the civil marriage will result for a couple living as life partners. However, prior to the Civil Union Act of 2006, when same-sex couples could not actually marry, the courts came to the rescue of such couples, and there was increased court recognition and legislative recognition of cohabitation for same-sex life partners. And cohabitation actually acquired a kind of status, a sort of marriage-like character. But heterosexual cohabitation, in which many South African women are involved, largely and often due to poverty and dependency, they are forced to enter into such relationships. That has not been really catered for adequately in our law, although the recent case of Bwanya, the recent Constitutional Court case of Bwanya, does come to their assistance. And many women have not been able to access and realize their rights. So, as I say, in Bwanya, the Constitutional Court was faced with a challenge that it was unconstitutional to deny opposite-sex life partners rights to claim maintenance from their deceased life partner's estate, in terms of the Maintenance of Surviving Spouse Act. It was a double challenge, because they also argued that it was unconstitutional to deny the right to inherit from the intestate estate of the deceased life partner under the Intestate Succession Act. And it's important to note that, in fact, same-sex couples had both those. They could claim under both those acts, but it seemed that opposite-sex couples were not allowed that claim. So, in terms of that act, the government was required to insert the word permanent life partner into those acts in order to ensure that a permanent life partner could claim maintenance in terms of both those acts, even though they weren't married. So, in view of all these difficulties, the South African Law Reform Commission has issued a discussion paper on a single marriage statute, 55 Project 144, in which it noted that the Constitution provides an opportunity to make a break with the past, And it was said that equality would bring not only a new respect for the African legal tradition, that's the polygamy, customary marriages, but also improve the position of women and children who had previously been disadvantaged. And this new marriage regime should incorporate the values of human dignity in terms of Section 10 of the Constitution, non-racism, non-sexism in terms of Section 9 of the Constitution, and the right to equality, all involved in the various subsections of Section 9. The other matrimonial law reviews which are taking place, the South African Law Reform Commission, as I say, is very busy. They've just issued this matrimonial property consequences, their report on this, Project 10E, and I will be talking a little bit about that. These reports, they are still busy on spousal support and maintenance and alternative dispute resolution. So there's a lot going on in matrimonial reform. And another point to make is that South African law matrimonial law is interesting. I think we are the only country in the world that actually has a system of law that allows for same-sex marriage and also for polygamy in certain circumstances. So it's a tremendously diverse and certainly quite a challenging situation to deal with. So there are three options really that the South African Law Commission has highlighted in its paper, and it has said made this very clear. The single marriage, the first option is that of a single marriage act, a unified or unitary set of requirements for all marriages and partnerships. And that is what the draft bill, marriage bill, has that we're going to be talking about later. The second option, which has also had a lot of support, is a single marriage statute, but with chapters which provide for the current legal requirements for civil marriages, civil unions, customary marriages, and other marriages and partnerships. And so it's more detailed on those and would try to ensure that all the provisions of these various acts are tested against the Constitution. And the third option is to preserve the current position with separate statutes to regulate every form of marriage presently recognized, including civil and religious marriages, customary marriages, civil unions, and the adoption of extra statutes, additional statutes regulating Muslim and Hindu marriages and life partnerships. It's important to note that Hindu marriages have also not been recognized like Muslim marriages, though fall into the category of religious marriages which are not recognized. So the South African Law Commission report has also produced this Project 104 single marriage statute. And they produced this report on the 17th of it was produced in 2021. The closing date for comment was the 17th of May. And there are two bills attached to this project report, this discussion paper, should I say. This discussion paper has two bills. They're actually identical, but they are slightly different in nomenclature. The one refers to all the different, including the life partnerships and religious marriages. It refers to them as protected relationships. And this one refers to marriages or life partnerships. But in essence, they are the same, and they're proposing a single statute to regulate all either protected relationships, and that includes all marriages and life partnerships. However, the draft bill, which has now been produced and is which gives effect to some extent to the white paper on marriages, which was approved by Cabinet in 2022, is now open for comment, and it was produced by the Department of Home Affairs, which, as I say, also produced a white paper to develop a single marriage act for the country. So it's drafted by the Department of Home Affairs, but interestingly enough, and in contrast to the proposals of the South African Law Reform Commission, it does not refer at all to life partnerships. There's no mention of life partnerships, despite the fact that this white paper did refer to, did refer to the intention to include life partnerships. And I'm not sure why they have now been left out, especially as apparently the South African Law Commission and the Department of Home Affairs met together in a workshop to discuss this, and they're obviously very keen to include life partnerships. It seeks to ensure that all marriages, it says, are concluded in accordance with equality and non-discrimination and human dignity, and its preamble cites many of the Bills of Rights, which would reflect Section 10 of the Constitution and Section 9, etc. And the public, as I say, are invited to give comment before the 31st of August. And it defines marriage as any existing marriage concluded in terms of the Marriage Act, Civil Union Act, Recognition of Customary Marriages Act, or any existing monogamous or polygamous marriage concluded either before or after the commencement of this act. And I assume that's just a sort of coverall for all existing marriages, recognized marriages. And then it also defines a polygamous marriage as is defined as a marriage in which a male spouse has more than one spouse at the same time. I find that a bit odd because the word polygamous actually is a more catch-all situation, which would include any marriages in which spouses are able to have more than one spouse. Polygyny would be the word, which would imply that just a male spouse has more than one spouse. And polyandry would mean that either male or females can have more than one spouse. So that's slightly problematic. But there are two categories really of marriage. There's all existing marriages there, and then there are parties to existing religious and cultural marriages who have an opportunity now to register their marriage in terms of this bill. They've got 12 months to register this bill, and then valid marriages entered into after the bill. So the aims of this draft marriage bill are that it aims to include all marriages, irrespective of sexual orientation, religious or cultural beliefs, under a single law. And it aims to provide certain requirements for the registration of marriage and the legal consequences of a marriage, consent to enter into a marriage, age determination, only persons, as we'll see, over the age of 18. So it absolutely prohibits any child marriages. And we'll look at the equal status as provided for spouses, solemnization, there's certain solemnization of marriages, and certainly provisions for the dissolution of marriages with reference to the Divorce Act, which is also being reformed, and I'll mention that. So clause 15 of the bill says that a marriage officer can solemnize a marriage at any place in South Africa, at any time, and in accordance with any religious practice. Now, a marriage officer in clause 11 is described as a person appointed by the Minister of Home Affairs. That could be from a religious denomination or even a traditional council, and maybe for a specific religion or a specific customary practice in terms of clause 11.2. And they have to be fit and proper persons. They have to have gone through training, South African citizens, and no convictions or anything. So those would be the marriage officers appointed by the Department of Home Affairs. 2 witnesses need to be present during the solemnization of the marriage, and both parties need to be present, and no proxy marriage is allowed. Now that's interesting because in the white paper that preceded this bill, they allowed for proxy marriage because they said in certain cases of Muslim marriages, the bride is not present because they have gender separate weddings ceremonies. So that's obviously gone off the table now. They're not allowing any proxy marriages. And the parties obviously must have legal capacity, freely, and there must be free and informed consent, and they must be above the ages of 18. With regard to the proprietary consequences of the marriage, here they would refer obviously to clauses like the Matrimonial Property Act, etc. But all spouses have full status and capacity to enter contract. So that's a very good thing there. And prospective spouses must, prior to the solemnization of the marriage, voluntarily choose which matrimonial system where they want to apply to the marriage. So whether they want to be married out of community of property, with accrual, out of community property without accrual, or in community of property. And it also, the Act makes provision the bill makes provision, should I say, for changing matrimonial property regime for other spouses. And we'll look at the South African Law Reform Commission discussion paper on matrimonial property just now, which also makes provision for that. There is provision for polygamous, as I say, they call it polygamous, but anyway, polygamous marriage, that a male may take more than one spouse. But that's only when it is in terms of a religion, so it's religious marriages and customary marriages only. And that bill is very clear on that. The validity of a customary marriage is that both parties must be over the age of 18, give free informed consent, and have legal capacity. The husband must obtain the consent of the first wife or the preceding wives, and he must make application to the court to approve a written contract to regulate the future matrimonial property regime of his marriages. The bill doesn't say what sort of consent is required, so that's slightly problematic. The court must terminate the existing matrimonial property system, whatever they're married under, and effect a division of the matrimonial property equitably and consider the circumstances of the family groups and allow any amendments as time goes by, and grant the order subject to any conditions. They might grant the order for the marriage, or actually refuse it if they feel that some of the parties are not sufficiently safeguarded. And all parties, that would be all the previous wives and anyone who has an interest in the matter, should be joined. So also a court, the draft marriage bill makes provision for a court granting a divorce to granted on irretrievable breakdown. So it's referring to the Divorce Act, which as now the proposals being to be amended, as we'll see just now. A court granting a divorce has the powers in the Divorce Act and also needs to take into account equitable division, as in the case of polygamous marriage, which I've just mentioned there. So we also need to actually refer at this point to a draft divorce amendment bill of 2023, Government Gazette, which aims to safeguard. This is a measure to put into force what was proposed in the Women's Legal Center versus President of the Republic 2022 case, where the Constitutional Court gave the government 24 months to amend the legislation. So that this is, I think, very good. They've aimed to safeguard the welfare of dependent children of Muslim marriages and to provide for a redistribution of assets on the dissolution of a Muslim marriage, so that they can have the assets redistributed, which is exactly what the Women's Legal Center case was about. Provide for the forfeiture of patrimonial benefits of a Muslim marriage. And clause 1 inserts the definition of Muslim marriage, which was recognized by the Constitutional Court judgment in the Women's Legal Center versus President of South Africa case, to be part of South African common law. Clause 2 amends Section 6 of the Divorce Act by providing for minors or dependents of a Muslim marriage, and that's the children of a Muslim marriage. And Clause 3 amends Section 7 of the Divorce Act by empowering a court to grant a decree of divorce on the dissolution of a Muslim marriage. So recognizing a divorce in terms of Muslim law as well, so enabling those parties to get divorced and to make an order for the redistribution of assets. The bill seeks to amend, as I say, to extend its application to Muslim marriages and give recognition to them as valid marriages. and it follows on from that constitutional court case, which recognized that the need for protection. There's no mention of other religious marriages, such as Hindu marriages, which often don't even recognize divorce, so can leave parties in a very difficult position, as was seen in the case of in recent cases, and particularly in the case of Singh versus Rangasamy, the Rangasamy case, which I can talk about later. The advantages of the draft marriage bill. What are the advantages? Well, the spouses have equal status and capacity, so that's a good thing. It aims to eradicate child and any forced or arranged marriages in line with international standards. And so that's a good thing. The bill requires all marriages to be registered, not previously, all marriages to be registered. And that particularly applies to customary marriages, which were not previously registered in terms of the Recognition of Customary Marriages Act. And it gives parties 12 months to register their marriage, which will be a very good thing to have those customary marriages which are unregistered. Those that are on marriages which are unregistered, as I say, have 12 months. And the duty of the marriage officer is to submit all documentation for registration of a marriage within 14 days of the marriage being solemnized. Now, criticisms of the bill. The proposed legislation paints every marriage with one brushstroke. Is that going to be a problem? The bill also contains nothing about life partnership, and yet it claims in the preamble to be based on sections 9.1 and 9.3, which state there should not be any unfair discrimination against persons on the ground inter alia of marital status. The preamble to the bill also says that South Africa has international obligations to take appropriate measures to eradicate discrimination against women in marriages. So why then do we have polygamy still allowed? A woman in a customary marriage may not marry more than another man. So I think that is definitely discriminatory and probably also may well offend against the right to dignity. There's also criticism of the definition of lobolo. The Marriage Act defines lobolo as property in cash or in kind, which a prospective husband or the head of the family gives to the head of the bride's family. It implies only traditionally male family heads can receive it. But it ignores the fact that in 1997, in fact, the Transvaal High Court said that the bride's mother could negotiate and receive lobolo. And the bill needs to, I think, redefine this bride wealth as including money which could be paid over to the bride's family. So to take into account the fact that there might well have been a mother who had brought up the child who should be entitled to that bride wealth. So in conclusion, and I have wrestled with this, firstly, I was thinking, if the bill seeks equity and inclusion, why does it not recognize intimate partnerships, such as permanent life partnerships? Why does it not refer to those at all? It needs to take into account the fact that there are socioeconomic changes which require society to reevaluate traditional assumptions about accepted forms of relationships, the interaction of different cultures and relationships such as permanent life partnerships. Why does the bill perpetuate polygamy? And that is contrary, I would say, to Section 9 and 10 of the Bill of Rights. And then I worry about this one size fits all. Will that be able to accommodate diversity? Or will it simply continue to, is it trying to harmonize the irreconcilable? Does it mean that the discrimination that exists in certain marriages will be allowed to avoid detection? So my argument really is that perhaps we need to, sorry, just go back. We need to look at perhaps more carefully at an omnibus statute, which would be able to have greater potential to protect and offer substantive gender equality than an assimilation approach. Also, there's no basis in any African state for a successful unification of the marriage law into one statute. It has been argued that Muslim family would continue to be practiced regardless of non-recognition by the state, and that there's certain aspects of certain laws which would discriminate against, which would be allowed to discriminate. It's also been argued that the concept of a single marriage act is unlikely to succeed because it's based on a Western Judeo-Christian paradigm of marriage, which may be inconsistent with the ethos of legal pluralism. So those are just thoughts and criticisms. Thank you.
Thank you so much, Bridget. Can you hear me?
Yes, I can. I'll stop share now.
Thank you so much for that excellent and insightful presentation. Delegates, I hope you enjoyed that and derived benefit from it. Thank you all for your questions. We'll get to them in a moment. In the meantime, please do complete the poll on the screen, which will be up for a short while. And we'll get to the questions as soon as we can. I think, can we go to the questions now, guys? Okay. Let's just see what we have here. Okay, somebody's asked, I think you may have covered this, but somebody has asked, if marriage by proxy is not allowed, how will Muslim religious marriages be recognized?
Yes, thank you. I don't know, because they in the white paper they certainly acknowledge that there are gender separate ceremonies and this is one of the problems of a one-size-fits-all statute. If you insist that, you are actually Muslim marriages are forced to compromise to some extent. They're saying this is what you have. These are the prescribed ways of going into a marriage, and you have to compromise on that. So I mean, I don't know that is just something that those marriages, obviously, in terms of this marriage bill, that's perhaps a criticism that needs to be made. That it's not this insistence on no proxy marriage is not accommodating those Muslim customary separate ceremonies.
Okay, there's quite an interesting one here. The bill states that only persons over 18 can get married, and that child marriages are being done away with. Shouldn't this warrant changing the age of consent for sexual relations to 18 as well?
That's a very interesting question, but and I think that might well follow. I think that yes, that could well follow, and I'm not sure what the criminal lawyers would say about that. But they may well have to bring that into line with the Marriage Act. Yes, I think there will have to be other changes to other laws to bring it into line with that, definitely.
Yeah, that seems the way it might go. And then another quick one. What about Jewish religious marriages? Where do they fit in regarding the new bill? I mean, it covers religious marriages, but yeah.
Jewish religious marriages would have to conform to the Draft Marriage Act, and then they would be married, and then they would obviously, as long as they conformed with the provisions of the Draft Marriage Bill, they would fall in under religious marriages and be recognized.
Okay. And then
I presume that they would allow that a Jewish rabbi or whoever performed the marriage would be given status as a marriage officer, because the bill does make provision for the Minister of Home Affairs to allow traditional councils, and it makes specific reference to religious denominations being appointed as marriage officers for a specific religion.
Okay, thank you. And then another question, maybe linked to that. What is the legal position of the current South African law with regard to Hindu marriages? Why would the recognition of these marriages be difficult to fit into the one-size-fits-all proposals of the draft marriage bill?
Yes, that's a very interesting question. You have to go back, if I could go back to a little bit just to talk about Muslim marriages. In the case of Singh, which I think I did allude to, quite a very sad case. The plaintiff and her husband were married in terms of a branch of the Hindu religion which doesn't recognize divorce because it considers marriage to be an indissoluble sacrament, and both spouses were aware that they needed to get have their Hindu marriage and have a civil marriage, which is what they have to do any religious marriage now, and they knew that their marriage would not be recognized, but they didn't do that. They didn't go through a civil marriage, and in the end they never had their marriage recognized. The plaintiff wife wanted a divorce, and she tried to go to court. And what she actually wanted was either to have her Hindu marriage turned into a civil marriage so that it could be dissolved, or have the consequences of the civil marriage imposed on it so that she could obtain a divorce. But the court said, no, we can't do that. And that was correct at that time. So Hindu marriages are in a particularly difficult position because divorce is often not recognized. So they've got the option, as I say, to have another marriage, and the courts have come to their assistance, but they're very limited and piecemeal provisions for them. And in fact, there hasn't been any further litigation on Hindu marriages. So it's sad that, in fact, the divorce draft bill that I talked about only seems to be targeted to reforming the law in regard to Muslim marriages, but doesn't mention Hindu marriages. So again, they seem to have been left out when it comes to the recognition of the divorce the courts having some sort of say over redistribution of assets and looking after the dependents of those marriages. However, if you look at the South African Law Reform Commission proposals, they propose that in even a religious marriage, the courts should have the power to redistribute assets, so they would be able at least to redistribute assets on the dissolution of a relationship. But I still worry about how that they will get a divorce. A person married in terms of the Hindu religion will be able to get a divorce when it's not mentioned in the draft divorce bill. That's something that needs consideration by the legislature.
I think that was a very valid question.
Very valid point, very valid. I think it should be the person who raised that, thank you very much for raising that, should definitely take this up with the minister, with the Home Affairs before the end of August. Only got a few days to do it.
And now another one's just come through.
Yes.
Would it mean that despite a couple going through the whole procedure of a customary marriage, but it is not solemnized by a marriage officer, would that mean that the marriage would be invalid?
Yes, it would be. The marriage has to be solemnized by a marriage officer. That's very, very key. There's no, and that's just widened the pool of marriage officers. So you could get, I know the traditional council leaders are often very often play a role in the religious customary marriages. Sorry, they are now able to be appointed as marriage officers. Obviously, if they fit those quite strict requirements. Okay,
very interesting one. What changes to matrimonial property law are proposed by the South African Law Reform Discussion Paper number 160 on matrimonial property, which has just been released and is open for comment until 31 September 2023. How would this affect the marriage bill?
Yes, this is a very interesting issue here. The new marriage property proposals of the law reform discussion, the law reform paper, and just briefly, and I think it's open for comment. I'm just looking here, the 31st of September. They propose changing the default matrimonial property regime from an in-community property to out-of-community with accrual for all marriages in terms of the Marriage Act. That's Marriage Act 25, that's all the civil marriages. And then they also propose that there's going to be much greater, and it's actually in line with the UK law in a way, that ANCs are going to be much more regulated and explicitly legislated for. The parties should be subject to specific duties of disclosure in their ANCs, and parties should receive independent legal advice before they enter into an antenuptial contract or ANC. The courts may actually refuse to enforce an agreement or a term in an at divorce or separation of the parties if its enforcement would cause serious injustice or undue hardship to the parties. And in deciding whether there's serious injustice which will result from enforcement of the antenuptial contract, court will have a list of factors that they need to look at. There's a prescribed list of factors. If it's a polygamous marriage, polygamous marriages will be the default regime will be out of community of property in the case of a polygamous marriage without accrual. But they're different options. Obviously, the court will be then exercising a general discretion to redistribute assets. And obviously, when entering into a second or subsequent marriage, an application to court will have to be followed through. They propose that the nikah Muslim marriage contract should be recognized as a valid marriage contract. But it's very interesting that this bill gives the courts wide powers to redistribute assets where they feel that it's necessary.
Yeah. Gosh, it's amazing, all these tricky issues that are being raised. It's very interesting, and we, at this point, we probably can't be exactly certain of what's going to happen, but yeah, very interesting. Do you agree? I think, yeah. Okay, I think we may have enough time for another one. What are some of the challenges in extending protection to women and children involved in customary marriage in terms of the recognition on Customary Marriage Act? Bridget?
Yes, some of the biggest challenges really are, let me find that. I would say, sorry, I was looking for my. One of the biggest challenges is that of polygamy. It's very, very difficult to regulate this and to bring it in line with the Constitution. For example, there was in the white paper, if you look at the white paper, there was discussion about possibly having polyandry, in other words, allowing female spouses to take more than one husband. And the reasons for the rejection of this were firstly that polyandry is contrary, they said, to the dominant patriarchal culture, which accepts or tolerates that men are the ones who have multiple partners. Polyandry, it was stated, not that I agree, but is contrary to traditional and religious practices. That was a general statement that was fed back to the white paper. Thirdly, polyandry has the potential to negatively affect the family structure, and that there are difficulties associated with proving paternity for children who will be born in a polyandrous relationship. So that is one of the big problems. The other problem really is the non-registration of frequently of religious marriages, but that should go with this under the new proposals, where there's a clear duty on the marriage officer to register the marriage, and that the parties are required to take every effort to register their marriage. So those are some of the challenges. Traditional leaders have a recognized role now in the customary marriage, so that challenge has been overcome. So yeah, largely it is a problem of fitting custom into what has been criticized as perhaps a Judeo-Christian idea of marriage.
Yeah, okay, thanks for that. I think we might have time for one more. I see something comes through. A question. As societal perceptions of marriage evolve, should the legal definition shift from a primarily contractual arrangement to one that emphasizes partnership, mutual growth, and emotional connection? I'm not sure how you're going to respond to that. What are your thoughts, Bridget?
Yes, that's a very interesting definition. Obviously, the thing about marriage is that it is not just a contract. It involves a change of status. So it's a kind of sui generis contract. It is based on emotion and love and all those kind of things. And the problem is that a lot of young people will go into, say, a cohabitation relationship, and they think that they have rights. They think that they are in a common law marriage, but they haven't made that public commitment. And the common law marriage at this stage in our law, or permanent life partnership or cohabitation relationship, does not give you rights on dissolution of that relationship. So you can live together for, as in the case of you could only get the only protection you can get is in terms of the Maintenance of Surviving Spouses Act at the moment, and in terms of the Intestate Succession Act. So it's very difficult to say that it will just be that. There's got to be that public act with two witnesses present, etc., to make it into a fully recognized relationship. I think that if I could say that, there's in order for the law to come into effect. But I understand that. I think there would have to be some sort of public commitment, even a cohabitation agreement or something like that, in order to acknowledge that there is this relationship.
Okay, thanks. I think we're almost out of time. I'm hoping I can just answer one more question very briefly, Bridget. What are some of the challenges in extending protection to women and children involved in customary marriage in terms of the Recognition on Customary Marriage Act? And this will have to be our last question.
Well, the challenges are, and I think I've referred to them really, that polygamy is the Lobolo issues, the general dominance of male relationship, the fact that same-sex marriage is not allowed there for women, children I'm not sure exactly what is. I mean, child marriage would now be outlawed. Children would be automatically are automatically able to have proper maintenance from the husband. But yeah, I think the challenges are that, you know, the whole handing over of the bride, the lobolo, the polygyny, is in some ways just could be regarded as discriminatory against women. And I don't know how.
I'm afraid we've run out of time, unfortunately. So I'd like to just thank Bridget for that very insightful presentation and also for answering all of our questions so fully. Just for everybody, the webinar recording will be made available within a few days. So thanks, Bridget, and thanks for all of our delegates. And we're going to have to say goodbye now. Thanks, everyone. Bye.
Bye.
Bye-bye.
Bye-bye.